If you live in one of the roughly 30 million American homes governed by a community association, you already answer to something that can tax you, fine you until the fine is bigger than whatever you did wrong, and if you fall far enough behind, take your house and sell it. If you've ever gotten a violation letter over a color, a fence, a bin left out too long, or an assessment you never voted for, you've already touched the edge of this. You never voted on whether that organization should exist. You can vote for its board, you cannot vote it out of existence. And you can't leave without moving. Here's what that costs. In Denver, a man named Cordell Lovett Sr. had owned his home in Green Valley Ranch for about 20 years. He bought it for $110,000. He fell behind on his association dues. The association said he owed just over $6,000. Then the lawyers were added, another $4,400 in fees. His home went to auction and sold for $11,773. 5 months later, it resold for $325,000. A debt smaller than a used car took the whole house, and the money didn't go to him, and it didn't really go to his neighbors either. That isn't even the extreme version. In one Nevada case, a mortgage of $885,000 was legally wiped out by an association foreclosure. I'll show you exactly how that worked and why it mostly can't happen anymore, but something almost as bad still can in every state. First, though, the part that's genuinely legitimate, because most of it is. Somebody has to pay for the roof. When a community shares a road, a storm drain, an elevator, a pool, the shared stuff decays on a schedule whether anyone budgeted or not, and how you pay matters enormously. Take a $250,000 roof replacement. Save for it gradually through reserves, and it costs about $231,000 because the money earns interest while it waits. Get hit with a special assessment when the roof fails, and it costs the full $250,000. Borrow it, and it costs $320,000. So the boring monthly dues are not the con, they're the cheapest version of an unavoidable bill. And most associations aren't over-collecting, they're under-collecting. Across 100,000 professional reserve studies, only about a quarter are funded at the level the industry itself calls strong. A third of them sit in the weakest band, under 30% funded. That's where the surprise 5-figure assessment comes from. Not because the money was stolen, because it was never collected. Fine. The dues are real. Now watch what got built on top of them. Start with what an association actually is legally, because it's stranger than a club with rules. In 1983, a California appeals court describing a homeowners association adopted this description and built its reasoning on it. A quasi-government entity paralleling in almost every case the powers, duties, and responsibilities of a municipal government. And when the lawyers who wrote the model statute for these communities had to justify giving associations extraordinary collection powers, they made the same argument in writing. Association assessments, they said, are genuinely analogous to property taxes because the association is out there providing public services. Their list: paving, snow removal, open space maintenance, and land use enforcement. Paving, snow removal, and land use enforcement is a public works department with a private mailing address. It didn't appear by accident either. The federal government drafted the blueprint. There's a document, FHA Form 1400, Suggested Legal Documents for Planned Unit Developments, published by the Federal Housing Administration and the Veterans Administration to show developers how to write these things. The 400-page handbook that standardized homes associations nationwide was a study produced for the FHA, and two scholars writing for a federal commission later noted that from the 1930s onward, federal housing policy actively promoted binding deed restrictions and insisted they be vigorously enforced. Now, you'll often hear that cities forced this on developers to dodge the bill for roads. The truth is more interesting than that. That federal commission studying these associations in 1989 put it this way: planned developments create a lot of common space and common facilities that local governments typically do not wish to own and maintain. And at the same time, the developer usually wants to divest those properties. The alternative to public or developer responsibility is the residential community association. Read that again, because both halves matter. The city didn't want it, the developer didn't want it either, so it went to you. But hold the conspiracy. That same commission admitted that because these are private organizations, relatively little is known about what they actually provide or how they affect local government. When researchers finally measured it, municipal spending genuinely does fall where associations spread. So the "you're taxed twice" complaint is partly wrong. Partly. Because the one category that doesn't fall is roads. And ask the two sides and you get opposite stories. One state's League of Cities says flatly that cities do not require associations, while the association industry's own materials describe towns and counties seeking to transfer the burden of municipal services. Not a conspiracy, a convergence. The developer saved money, the city avoided a liability, the federal government supplied the paperwork, and the resident inherited a government. Here's what makes it stick. The document governing your house is a covenant that runs with the land. Not a contract you can renegotiate, but a burden attached to the dirt, which the law describes as an obligation that cannot be avoided by non-use or by withdrawal. You can't quit, you can only sell. And in Florida, the state's own mandatory disclosure form warns buyers in capital letters that the developer may have the right to amend the restrictive covenants without the approval of the association membership. Your window to walk away is 3 days or closing, whichever comes first. The exact moment the obligation becomes permanent is the moment your right to refuse it expires. So, a body with a city's powers. Does it have a city's limits? No. A woman in Florida wanted a for sale sign in her own yard. Her association banned signs. She sued on First Amendment grounds and the federal appeals court threw it out, not because the ban was reasonable, but because the association isn't the government. No state action, no constitutional claim. In New Jersey, an appeals court once held that a large association was effectively performing municipal functions and had to respect free speech. The New Jersey Supreme Court reversed that. Homeowners there can still win speech cases, but only because New Jersey's state constitution is the rare one that reaches private conduct at all. Everywhere else, whatever protection you have came from a statute a legislature chose to pass. Congress protected the American flag, the FCC protected satellite dishes. Some states protect political signs. But you get no constitutional due process, only whatever your state wrote down. And when you argue a rule is unreasonable, California's Supreme Court has already held your specific hardship is close to legally irrelevant next to the rule itself. Which brings us to the only question left. Who makes money from this? Because this is where it stops being about lawns. Americans paid $124 billion in association assessments last year. That attracts an industry. Look at the largest publicly traded association manager in North America and read its own investor deck. In 2024, of about $2.1 billion in revenue, just 18% came from the management contract itself. The other 82% came from everything else it sells the communities it manages: engineering, front desk staffing, maintenance. Its financial affiliate advertises $6 billion in managed funds, over 200 loans placed a year, and an in-house insurance brokerage. The management fee is the entry ticket. The building is the store. Even the paperwork is a product. In Florida, the document confirming what you owe when you sell, the estoppel certificate, is capped by law at $299, plus another $179 if you're behind, plus $119 if you need it fast. Nearly $600 for a piece of paper. And a Florida legislative analysis noted something quiet about it. Associations usually don't even prepare these. Their management firms do. Some associations keep the fee, others hand some or all of it to the management firm, in the analysis's own words, as additional income. But the sharpest version is the collection business, and here the numbers stop being abstract. A Colorado law firm representing around 50 associations told a court what a typical uncontested foreclosure generates in attorney fees: between $4,000 and $6,000. Read that again. The fees on a case nobody is fighting are routinely larger than the unpaid dues that triggered it. The debt isn't the product. The debt is the raw material. Carl Pema, a former NFL cornerback, got a certified letter over an association debt of $1,515. By the end, claimed attorney fees had reached roughly $50,000. A judge struck more than $30,000 of it as excessive. He still paid $25,774 in total to keep his own house, 17 times the original debt. And this isn't a handful of horror stories. Reporters in Colorado went through 6,000 court cases and found associations filed around 3,000 foreclosure actions in about 5 years. More than 250 homes were auctioned. At least 100 sold for $60,000 or less. But look at the shape. Only about 8% of filings ever reached an auction. The filing itself is the instrument. Most people find the money. So here's the test that settles it. If these foreclosures were driven by genuine necessity, by associations with no other way to collect, then changing what the lawyers get paid shouldn't matter much. In 2024, Colorado capped recoverable attorney fees at the lesser of $5,000 or half the amount actually owed, required 30 days notice, made associations offer mediation, and forced them to attempt a payment plan first. Filings collapsed from an average of 281 a year to 47 in the first 6 months under the new law, roughly a 2/3 drop. Now, be fair about it, Colorado's HOA attorneys say some of that pause is procedural because associations had to rewrite their collection policies and reissue notices, and in the 10 weeks between signing and the effective date, filings spiked, a rush to beat the deadline. But 2/3 of a practice does not disappear because the need for it disappeared. There's one more power worth knowing, and it's the one people get wrong most often. In about 20 states plus Washington, D.C., an association's lien for unpaid dues doesn't sit behind your mortgage. For a few months' worth, it sits in front of it. 6 months is the model, but it runs from 4 months in Maryland to 12 in Florida and 9 in Nevada. And in a handful of those places, courts went further and held the association can foreclose that slice and wipe out the mortgage entirely. 2 caveats before you panic. In roughly half those states, the rule lives in the Condominium Act, so it reaches condos and not single-family homes. In the Nevada case that made this famous, a house sold at an association auction for $6,000, and the mortgage extinguished behind it was $885,000. That figure doesn't come from an activist, it's from a joint statement signed by the banking industry. 2 things stop that being the whole story. First, why 6 months? Not because legislatures picked it, because Fannie Mae and Freddie Mac's rules refuse to back a mortgage where an association can jump ahead by more than that. And we know what happens when a state ignores them, because Rhode Island tried. It passed a 5-year super lien in 1991 and cut it back to 6 months the next year, because condominium lending in the state essentially stopped. The number in your state law was set by 2 mortgage buyers, not by your representatives. Second, and most coverage skips this, the wipeout has largely been closed. Since 2015, the federal housing regulator has said it will never consent to a foreclosure extinguishing a Fannie or Freddie interest. The courts agreed. The Supreme Court declined to revisit it in 2019. Those 2 companies stand behind more than 40% of American mortgage value. So the doomsday version isn't most people's risk anymore. The everyday version, the fees, the filing, the auction that sells a house for a fraction of its worth, very much is. And to be genuinely fair at the end, because the fair version is the sharpest one, that priority lien exists for a real reason. It was designed assuming a lender would foreclose within 6 months. In practice, foreclosures now average well over a year, and some allowed timelines ran past 2. All that time, the association still has to plow the road, insure the building, and light the parking lot, and if it can't collect from the one owner who stopped paying, that cost lands on the neighbors who didn't. The model law already bans foreclosing over less than 3 months of dues, and bans it over fines alone. And in both kinds of case, the Nevada wipeouts and the Colorado auctions, the association didn't get rich. It collected its few months and its fees. The windfall, the house worth $300,000 bought for $11, went to whoever showed up at the auction with cash, which is the shape of the whole thing. A country decided new neighborhoods should pay for their own roads. The federal government printed the forms. And to make sure the money got collected, it handed a private board the 2 powers that make a government, the power to tax and the power to take. Then it attached almost none of the limits and left the rest to 50 separate legislatures to fill in one statute at a time. The Constitution stayed outside at the entrance sign. An industry noticed that a board with the power to take a house and a fee schedule that pays by the filing is a very reliable business. And when one state made that business unprofitable, 2/3 of it vanished in 6 months, which tells you it was never really about the dues. So, a question for the comments, and I read them. Have you ever been fined, billed, or threatened by your HOA over something you thought was absurd, and what was the number by the time the letters stopped? Especially if the fees ended up bigger than the thing you supposedly owed.